Welcome to Leading on Risk, a Lockton professional and executive risk video series in which we share insights on the risk topics that matter most to your business. I am Marie-France Gelot, a Senior Vice President in Lockton's Professional and Executive Risk Group. The second Trump administration has made diversity, equity, and inclusion, or DEI, a major focus area in 2025. Through executive orders and other actions, the administration has pushed back on DEI initiatives that many employers have championed in recent years. This creates a range of risks for employers and senior company leaders. We'll discuss these trends and how organizations can respond to them during this episode of Leading on Risk with Kelly Thoerig, Lockton's Directors and Officers and Employment Practices Liability Leader, and Eric Meyer, a partner at Pierson Ferdinand LLP. Eric, let's delve right in. Where do things stand at the moment with the Trump administration and DEI?
Well, Marie-France, the administration has moved fast. In January, President Trump signed an executive order that revoked prior DEI directives and told agencies to eliminate what it calls illegal DEI and illegal preferences. Then, in March, the EEOC and Department of Justice issued joint guidance saying Title VII is violated if decisions are motivated even in part by race, sex, or other protected traits. The message was that employer intent doesn't matter. Calling it a DEI initiative doesn't make it lawful. In May, DOJ launched its Civil Rights Fraud Initiative, signaling that contractors and funding recipients could face False Claims Act suits if they misrepresent compliance. By July, the Attorney General warned that even proxy criteria like cultural competence or lived experience may be unlawful. So the federal government has clearly shifted to a stricter stance.
So Kelly, what kind of unlawful practices has the administration been focusing on?
So the July memo by Attorney General Pam Bondi that Eric referenced, it explicitly states that it's non-exhaustive, but it does lay out a few examples of popular DEI practices that employers have utilized in the past that are now prohibited. Programs that grant preferential treatment based on protected characteristics, like programs or scholarships that are designed exclusively for students of a specific race. The cultural proxy issue that Eric mentioned, as well as trainings that promote discrimination or lead to a hostile work environment. Because they reference things such as toxic masculinity or white privilege. Again, it's non-exhaustive, and there's a litany of different examples, most of which are drawn from the higher education realm. But I think the message is clear that the current administration intends to apply these new standards of what is illegal DEI to a much broader base of employers.
So what does all this mean for employers? And Eric, we'll start with you.
Well, for employers, the key is risk management. The EEOC has highlighted practices that can cross the line. Things like placement or exclusion from candidate pools, exclusive employee groups that limit membership, or training that stereotypes or segregates. The Department of Justice has added the possibility of treble damages lawsuits if companies certify compliance while using unlawful practices. That doesn't mean DEI is off the table. It means every program needs to be tested against Title VII. Are decisions tied to protected trades? Could membership rules or training content be seen as exclusionary? Those are the questions to ask. Employers that build initiatives around fairness, neutrality, and opportunity are better positioned to manage the current enforcement climate.
So Kelly, we've talked about what the federal government is doing, but where else are legislators and policymakers taking a stance on DEI?
This is one of the many challenging areas for employers, especially those with multi-state operations. There has been, really predating the current Trump administration over the last few years, an increase in sometimes conflicting state and local legislation and enforcement. So, for instance, since 2023, there have been a number of state-level DEI bans or restrictions. Probably 15 to 20 states have some sort of restriction around DEI. Conversely, in February of this year, there was a memo issued by 16 state attorney generals on the, quote, continued viability and important role of DEI efforts. So It shows just how fractured this issue is when you have almost equal numbers of states and localities prohibiting it or limiting employers and other organizations' use of DEI, and an equal number supporting and encouraging organizations to find ways to maintain DEI programs.
So let's take a look at the litigation and regulatory environment that businesses face. What are the big issues that are emerging for employers?
Two issues really stand out. First, enforcement risk. Department of Justice's Civil Rights Fraud Initiative means contractors and grant recipients could face False Claims Act cases with treble damages and whistleblowers in the mix. That's a huge lever for the government. Second, you've got litigation risk. We're already seeing more so-called reverse discrimination claims, where employees allege they lost out on hiring or promotion because of DEI targets. The EEOC has made clear that using race or sex, even as one factor, is unlawful. Those two fronts, enforcement from the government and private litigation, create a more volatile environment for employers, more so than we've seen in recent years.
Kelly, any thoughts?
So I think, first and foremost, when we're talking about risks for employers, we're thinking of claims that would typically be covered by a traditional employment practices liability policy. And certainly discrimination or reverse discrimination, as the case might be, is a pretty classic EPL claim. These False Claims Act exposures that Eric's referenced are more likely to find coverage under a director's and officer's liability policy. And it's I think we need to underscore how novel this use of the False Claims Act is. The Trump administration has already shown a desire to use the False Claims Act in other capacities around tariff evasion and cybersecurity concerns. And while I think we are yet to see an instance of a criminal prosecution of DEI issues, the administration has emphasized multiple times over that is something that they intend to do. The other issue I guess I would want to note is relating to directors and officers liability insurance, and something that I think D&O underwriters are keen to is a potential increase in securities claims following on perhaps one of these False Claims Act issues or some other enforcement action. So, your mileage may vary on D&O coverage for a False Claims Act, depending on whether your program limits entity coverage to a securities claim and if individuals are named as defendants or otherwise implicated. But I think this is a really interesting issue that warrants us taking a more holistic approach to the risks that it presents, because they don't really fit neatly into one line of insurance or another.
So you talked about the risks for organizations as employers. What about corporate governance concerns?
So there has undoubtedly been a dramatic shift in the boardroom from just 5 years ago. In 2020, public attention was on the Black Lives Matter movement. That was just a few years after the launch of the Me Too movement. And, at that point, businesses and schools were under pressure from their employees, from students, from customers, from stakeholders to really embrace DEI initiatives. That was coinciding with a larger push by activist investors who were seeking to force public companies to commit to various environmental, social, and governance principles, ESG principles. Now the pendulum is swinging in the complete opposite direction, and we're seeing companies pull back from touting DEI programs and making public pronouncements and things of that nature, and a less is more approach seems to be the tact that many organizations are taking at this point, at least in terms of publicly stating what they are doing. I think there are still ways in which organizations can maintain a compliant DEI program without retreating from the concept entirely, but we're just seeing less discussion about it in the public forum.
And drilling down on organizations, are there any organizations in any specific industries that are impacted in specific ways?
Certainly educational institutions, higher education. That industry was directly targeted by the July Bondi memo. Also, federal contractors or any organizations that receive federal funds and grants, given this new False Claims Act exposure issue, I think need to be particularly attuned to this issue. But again, it's unfortunately a situation where no industry is immune. And I think it's something that all employers, regardless of whether they're on this hot list or not, need to be mindful of.
So let's turn to the issue of litigation. Eric, what kind of litigation do companies need to be prepared for, and have we seen any actual cases thus far?
Companies need to prepare for two main types of cases. First, Title VII claims, where employees allege they were disadvantaged by DEI-driven decisions. We've already seen filings along those lines. Second, False Claims Act suits against federal contractors and grantees. DOJ has been explicit that if you certify compliance but run DEI programs that allocate benefits or burdens based on race or sex, you're at risk. We're still early in this cycle, but the trend line is clear. More so-called reverse discrimination claims in court and more government actions testing DEI compliance.
And Eric, what additional regulatory activity do you anticipate going forward, either from the federal government or from the states?
So looking ahead, we may see more DOJ guidance, especially tied to federal funding. The July memo already identified proxies like cultural competence and lived experience as red flags, and more categories may follow. On top of that, both DOJ and the EEOC have said they will devote enforcement resources to these issues, so employers should anticipate follow-up in audits and investigations. The direction is consistent. Additional scrutiny of DEI framed as unlawful preferences, and pressure on organizations to show their initiatives are compliant.
Kelly, any additional thoughts?
I think we should expect more of the same, this ongoing fracturing with conflicting and competing regimes across state lines. State law, from an employment law perspective, often can differ from federal law, provide additional causes of action, more generous types of relief, longer statutes of limitation. And it's something that, again, multi-state employers and global employers, I think, need to be very cautious about. As the U.S. appears to be retreating from DEI and similar initiatives, the European Union, for instance, is going in the other direction and putting a lot of emphasis on pay equity and board diversity and things of that nature. So a one-size-fits-all approach, if it ever worked before, is no longer the tact for employers to take, and need to be very mindful about where they have exposure and liability and which jurisdictions laws could potentially apply to them.
So let's close with some recommendations and advice for employers, starting with insurance. So Kelly, how can organizations and its senior leaders make sure they have effective insurance coverage?
Well, consult with your trusted insurance advisor. A lot of these issues that we've been talking about are typical or classic employment practices liability insurance claims, and if that is not a policy that you currently have in place, it's probably a good time to consider that, as well as overall limits adequacy of your management liability suite of policies, to include employment practices liability, directors and officers liability. We haven't spent much time on it, but there is also a fiduciary liability component potentially to some of these issues. So just making sure you're taking a kind of holistic view of what your exposures are and matching that to the risk solutions that are in the marketplace. And obviously, ensuring that you have adequate legal counsel guiding you along the way. If a large organization might have a in-house legal department that's equipped to advise on these types of issues, but if not, I think organizations should be consulting with outside legal counsel to determine what their obligations are.
And as a follow-up to that, are underwriters asking more questions around DEI, and are they applying more scrutiny towards renewals?
Absolutely. I mean, what once was a feather in the cap has become a liability. So, in years past, perhaps it was a check-the-box exercise. Do you have a DEI program? Do you have a chief DEI officer? I think we're seeing more nuanced and specific questions around how a particular organization, depending on where they are located or where their employee base is located, how they're managing these dramatic shifts at the federal level, as well as overlaying that with any state or local specific obligations and laws that might apply to them.
And lastly, any final words of advice for employers, Eric?
Yes, from a legal standpoint, start with an audit of your DEI programs. Look closely at whether any goals or criteria rely on protected traits. Review employee groups and training content to confirm they are inclusive and don't segregate. And make sure you document your compliance rationale. If you face a regulator or a lawsuit, being able to show how you structured your initiatives around equal opportunity can be a strong defense.
And Kelly, any final thoughts?
Title VII is still very much in effect. The views of the Attorney General and the DOJ do not change the law. They represent the administration's interpretation of the law or advocacy for changes in the law. And threading that needle, I think, with how you message these changes, if an employer is making changes to your employee population, and being mindful about the impact that can have on your people, I think will go a long way. The pendulum is likely to swing back at some point in the future, and employers should be mindful not to overcorrect to the point of creating additional liability that they might not want to take on.
Excellent discussion today. Thanks, Kelly and Eric, for joining me. And thanks to all of you for joining us. For more insights from Lockton, subscribe to our YouTube channel, follow us on LinkedIn, and visit our website, lockton.com.